Okay, so welcome to this afternoon's episode of Legally Raven Haired, Legally Ignorant. Still trying to figure out our name. Hopefully, we'll know by June. So, we read this morning Worldwide Volkswagen, and today we're going to just go over some notes and questions. So, first of all, it reaffirms the threshold of requirement of contacts. So, even if it would, here you see it here. So, sometimes, even if a form state has a strong interest in applying the law to the controversy, even if the form state is the most convenient location for litigation, the due process clause acting um, as an instrument of interstate federalism may sometimes act to divest the state of its power to render a valid judgment. So basically, contacts of the form state are an essential requirement, even if personal jurisdiction will nevertheless be fair and reasonable in the form. So it's fair, it's reasonable, it's convenient. But if their contacts in the form state are not there, it's an essential requirement, and the state is divested of its power to render a valid judgment. So contacts are not enough. So contacts are a necessary requirement, but they're not sufficient to establish specific jurisdiction. Worldwide explains that in addition to having contacts in the form state, the relationship between the defendant and the forum must be such that it is reasonable to require the corporation to defend the particular suit which is brought there to determine whether jurisdiction is reasonable in any given case. World Wide Web instructs courts to consider several factors. Implicit in this emphasis on reasonableness is the understanding that the burden on the defendant, while always a primary concern, will, in an appropriate case, be considered in light of other relevant factors, including the forum state's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective relief, at least when the interest is not adequately protected by the plaintiff's power to choose the forum. The interstate judicial system's interest in obtaining the most efficient resolution of controversies and the shared interest of several states in furthering fundamental substantive social policies. So let's go here. All right. Thus, after World Wide Web, the exercise of specific jurisdiction is constitutional only when the defendant had purposeful, deliberate contacts with the form state, the plaintiff's claim arose out of those contacts, and personal jurisdiction is reasonable based on the consideration of the factors mentioned above. Foreseeable contacts. What purposeful contact did the defendant supposedly have in Oklahoma? Why did the court nevertheless conclude that the defendants did not have any purposeful contacts in Oklahoma? How does Justin Brennan's view differ from the majority position? So the plaintiffs argued that the defendant had contacts in Oklahoma because the defendant should have foreseen that any cars purchased in New York could cause injuries in Oklahoma. The court rejected this argument. The court explained that just because a manufacturer can foresee that a consumer might bring the manufacturer's product into the state and cause injuries there does not mean the manufacturer had purposeful contacts in the forum. In this case, two of the defendants, the dealership and the regional distributor, did not direct any activity specifically toward Oklahoma. Rather, the plaintiffs made the unilateral decision to drive the car into the state. As a result, the defendants did not have a purposeful contact with Oklahoma. In his dissent, Justice Brennan appears to concede that international issue probably supports the majority conclusion that the defendants did not have purposeful contacts in Oklahoma, but he argues that the court should revise its approach to personal jurisdiction. Yet again, in light of society's increasing mobility, he calls for a test that focuses on more than the defendant's contacts. The conclusion I draw is that constitutional concepts to fairness no longer require the extreme concern for defendants um, that was once necessary. So rather, context must exist among the parties, the contested transaction and the form state. The context between the two of these should not be determinative. Justice Brennan's test will focus on the overall reasonableness of jurisdiction, which sounds a lot like the approach that the court appeared to endorse in McGee and subsequently rejected in Hansen. The problem with foreseeable context, the court concludes that a defendant does not have a contact with the state simply because a consumer unilaterally transports one of the defendant's goods into the forum. Why does the court believe that a contrary holding would be problematic? How does Justice Brennan respond to the majority concerns? According to the court, defendants must have some control over where they subject themselves to the lawsuit. Otherwise, personal jurisdiction would be unfair. So this person buys this, they unilaterally decide to take it somewhere, and then you have no foreseeable way to know that you have liability in that particular place because you weren't involved in the decision. So the due process clause, by ensuring the orderly administration of laws, gives a degree of predictability to the legal system and allows potential defendants to structure their primary conduct with some minimum assurance of where that conduct will make them liable to a suit. Justice Brennan, in contrast, does not believe that due process requires the defendant to have this sort of control. He says, given the tremendous mobility of goods and people, and the inability of businessmen to control where goods are taken by customers or retailers, I do not think that the defendant should be in complete control of the geographical stretch of his amenability to suit. Jurisdiction is no longer premised on the notion that non resident defendants somehow impliedly consented to suit. People should understand that they are held responsible for the consequences of their actions, and that in our society, most actions have consequences affecting many states. When an action in fact causes injury in another state, the actor should be prepared to answer for it unless defending in the state would be unfair, um, for some reason other than state boundary must be crossed. So why is it unfair that you go to this state? It's like, look, you're in business. You have to understand that people's lifestyles now are very mobile. And so when you go into business, you should understand that your goods can be taken someplace else. And you have to be prepared for that. And unless it's unreasonable, you should have to defend the case there. And unreasonable does not mean in another state because people are so mobile. Although Justice Brennan's position did not prevail, his view does make a certain amount of sense. Given that travel and communications are relatively easy and inexpensive today, it is reasonable to ask whether a defendant should be permitted to exercise extensive control over where the lawsuit is filed, absent some real evidence of prejudice from litigating in the plaintiff's chosen forum. What if jurisdiction is very, very reasonable? So there's two varies. If the claim is arisen out of the defendant's context in Oklahoma, would personal jurisdiction have been fair and reasonable in the state? In other words, would the reasonableness factor have been satisfied? Almost certainly. Consider some of the reasonableness factors described before. First, Oklahoma had a strong interest in adjudicating the dispute there because the accident occurred in Oklahoma. Second, the plaintiffs had a very strong interest in litigating in Oklahoma. Keep in mind that their original destination was Arizona. They stayed in Oklahoma because they had been badly injured. Litigation elsewhere would have been very inconvenient for them. See Charles W. Adams, the Worldwide Volkswagen v. Woodson, the rest of the story, 72 from 1983. And third, many of the witnesses and much of the evidence was in Oklahoma, making it the most efficient location for the resolution of this controversy. Oklahoma, in short, seems like a pretty fair place to litigate the case. Worldwide demonstrates that no matter how reasonable personal jurisdiction might be, specific jurisdiction does not exist unless the defendant has some kind of contact in the forum. Because the defendants had no contact, the Oklahoma courts exercise of personal jurisdiction was unconstitutional. So we see here it made sense. First, Oklahoma had a strong interest because the accident occurred there. So that's number one. Second, the plaintiffs had very strong interest in litigating in Oklahoma. They got stuck there because they were badly injured, right? And then third, you have many of the witnesses and evidence was in Oklahoma, making it the most reasonable place for that too. However, reasonableness does not automatically give a court specific jurisdiction. Foreseeability versus certainty. Consider the following scenario. Imagine that you are a New Mexico citizen and that while traveling in Arizona, you enter a local hardware store looking for a chainsaw. You tell the owner that you intend to bring the chainsaw back to New Mexico, and the owner then sells you the chainsaw. You return to New Mexico, are injured by the chainsaw, and file a lawsuit in New Mexico against the hardware store. Would it be constitutional for the New Mexico court to exercise personal jurisdiction over the store? Yes, because the customer told the store owner that where the chainsaw was being taken, the owner directed a contact to New Mexico. No, if he advertised to New Mexico and the person came in because of it, it would be different. But the person just happened to come in the store. Yes, regardless of whether or not the owner knew where the chainsaw was being taken, the owner should have foreseen that a small product like a chainsaw could be used in a neighboring state. No, although the claim arose out of the defendant's contact with the state, personal jurisdiction would be unfair and unreasonable in this case. No, the claim does not arise out of the defendant's contact with New Mexico, or yes, although the store's contact with New Mexico is indirect, the reasonable factor overcomes the weak contacts that exist. No, although the claim arose out of the defendant's contact with the state, personal jurisdiction would be unfair and unreasonable in the case. So no, the claim does not arise out of the defendant's contact with the state. The defendant wasn't in New Mexico. The defendant was in Arizona. So it's D. B is incorrect. New Mexico, approximately. C is wrong for 2 reasons. E. D. There would not be personal jurisdiction here. The defendant did not direct the product to Mexico, and the defendant did not otherwise avail itself to the privilege of doing business in the state. All right. Lawyering strategy, re-arguing McGee. If Lulu McGee's case arose after Worldwide and you represented her, how would you have argued that the California court had personal jurisdiction over the insurance company? After World Wide Web, the argument in McGee would have been structured around the elements of the specific jurisdiction analysis. First, you should identify the context that the insurance company had with California. In particular, the company purposely sent an offer of insurance to Lowell Franklin in California, and the company also sent a reinsurance certificate to Mr. Franklin in California. You should argue that Ms. McGee's claim arose out of those purposeful contacts. You could note that the insurance company contact with California involved an offer to renew the very policy that was at issue in the lawsuit. There is therefore a strong argument that the claim arose out of the defendant's contact with the forum. Finally, you should argue that it would be fair and reasonable to subject the insurance company to personal jurisdiction in California using the 5 factors identified in Worldwide. You should point out that California has a strong interest in adjudicating the dispute, even the insured and beneficiary's residency in the state. The court noted McGee, the plaintiff, has a strong interest in having the case heard in her home state, given the cost and inconvenience of litigating elsewhere. California will also be efficient place for litigation, given the presence of witnesses who could testify in the cause of Franklin's death. Although the insurance company might be inconvenienced to some degree, if it's this inconvenience alone not sufficient to constitute a due process violation. The accidental tourist. Consider the following scenario. Imagine that during a driving trip from Pennsylvania to Maine, Donald takes the wrong turn and unbeknownst to him drives into Vermont. Before Donald discovers his error, he hits Penelope. Penelope sues Donald in Vermont, and Donald moves to dismiss the case for lack of personal jurisdiction, assuming that Vermont's long-arm statute authorizes jurisdiction over the action. The motion should be denied because the case arises out of Donald's contact in Vermont. A. Granted, personal jurisdiction will be unreasonable in this case, even if Donald's accident is considered to be contact with Vermont. Granted, Donald did not purposely avail himself to the privilege of driving in Vermont because he drove to Vermont by mistake. As a result, he lacked any constitutionally cognizable contact with Vermont. Granted, not only did Donald lack any context in Vermont, but the exercise of personal jurisdiction would be unreasonable under the circumstances. It's going to be A, denied because the case arises out of Donald's context in Vermont. The goal here is to apply the underlying rationale of the applicable legal principle to come up with the best answer or argument. Recall that in the Worldwide Court offered 2 rationales for a contact-based analysis, ensuring that courts operate within the territorial authority and preventing unfairness to defendants. Here, Donald did enter Vermont's territory, albeit unintentionally, so the Vermont court would not be overstepping its territorial authority if it asserts that Donald had contact with the state. Moreover, it certainly seems fair to exercise personal jurisdiction over someone who drove into a state and injured someone there. Using this logic, purposeful availment does not mean that Donald had to be aware that he was entering Vermont. All that matters is that Donald purposely drove his car into an area that happened to be in Vermont. Most courts would find that this to be a contact, thus ruling out C as the best answer. The reasonableness part of the inquiry would also be satisfied because Donald injured someone while driving in Vermont. A Vermont court would have strong interest in hearing the case. All the witnesses will probably be in Vermont, making it the most efficient location for the lawsuit. Also, assuming Penelope is a Vermont citizen, fairness favors Vermont for that reason as well. The reasoning rules out B and D, and thus the best answer is A. Yay! Elaborating on the definition of a contact, the United States Supreme Court decided several personal jurisdiction cases after Worldwide Volkswagen. The questions below are based on 2 of those cases, each of which involved an application of the minimum contact analysis to a libel claim. Publishing, how do you say it? The libelous? I don't know how to say it. Let's see. Libelous, containing or constituting libel. Libel, published a false statement that is damaging to a person's reputation, a written defamation. All right, that's what I thought it was, just to make sure I'm not confused. All right, so in Keaton v. Hustler magazine, Keaton sued Hustler magazine, a nationally circulated publication, for libel in New Hampshire. Although Keaton was a citizen of New York, whose only connection to New Hampshire was that the libelous magazine had been distributed there. She sued Hustler in New Hampshire because it was the only state where the statute of limitations for her claim had not yet expired. Keaton's libel claim alleged damages to her reputation in New Hampshire and nationally, though her damages in New Hampshire were relatively small. What would you expect the court to say about whether there was personal jurisdiction in the case? There isn't personal jurisdiction in the case. Keaton's contacts with New Hampshire are insufficient to give rise to personal jurisdiction there. There isn't personal jurisdiction in the case. Hustler's contacts with New Hampshire and Keaton's damages there were insufficient to give rise to jurisdiction. There is personal jurisdiction. The claims arise out of Hustler's contact with the state of New Hampshire. B. It's important to, I was wrong. Okay. So A is wrong. Personal jurisdiction typically has little to do with the plaintiff's context in the form, right? It's about the defendant's contact with the form. A contact might consider the plaintiff's connection with the form when analyzing the reasonableness factors, but as the worldwide clearly illustrate the plaintiff's interest in a convenient form cannot by itself confer personal jurisdiction. B is wrong because Keaton's reputation was damaged anywhere the magazine was sold. Damages may have occurred elsewhere as well, but she did suffer some damages in New Hampshire. One issue in the case concerned whether Keaton could sue for all her damages nationwide in New Hampshire, and the court held that she could. The court explained that if libel plaintiffs could not sue for all the damages in one state, there was a potential for a serious drain of libel cases on judicial resources. Allowing one forum to decide nationwide damages protects the defendant from harassment resulting from multiple suits. Ultimately, the court concluded monthly sales of thousands of magazines cannot, by any stretch of the imagination, be characterized as random, isolated, or fortuitous. It is therefore unquestionable in the New Hampshire jurisdiction over a complaint based on those contacts will ordinarily satisfy the requirement of due process that a state's assertion of personal jurisdiction over a non-resident be predicated on minimum contacts between the defendant and the state. Therefore, C is the best answer. There is personal jurisdiction that can arise at Hustler's contact with the state of New Hampshire. Okay. Not New Hampshire, but not only New Hampshire, but in New Hampshire. Writing and editing a libelous article. In Calder v. Jones, the facts were similar to Keaton, but with a twist. A writer and editor wrote an article in Florida about Shirley Jones, one of the stars of the old TV show The Partridge Family, who was a California citizen. The article suggested that Jones was a heavy drinker and that she cannot fulfill her professional obligations. The National Enquirer published the article nationally, including in California. Jones sued the National Enquirer, the writer, and the editor in California, alleging libel and related claims. Although the National Enquirer conceded personal jurisdiction wisely, given the contemporaneous holding in Keaton, the reporter and the editor contested it. Did the California court have personal jurisdiction over them, even though they wrote and edited the article in Florida? What would you expect the court to say? The court held that California exercise of personal jurisdiction over the reporter and editor was constitutional. It offered the following reasoning. The allegedly libelous story concerned the California activities of a California resident. It impugned the professionalism of the entertainer whose television career was centered in California. The article was drawn impugn, dispute the truth, validity, and honesty. It impugned the professionalism of an entertainer whose television career was centered in California. The article was drawn from California sources, and the brunt of the harm in terms of both the respondent's emotional distress and the injury to her professionalism, her professional reputation was suffered in California. In sum, California is the focal point both of the story and the harm suffered. Jurisdiction over petitioners is therefore proper in California based on the effects of the Florida conduct with California, of their Florida conduct in California. Worldwide, Volkswagen 444, US 286, 297, 298, 1980. Petitioners argue that they are not responsible for the circulation of the article in California. A reporter and an editor, they claim, have no direct economic stake in their employer's sales in a distant state, nor are ordinary employees able to control their employer's marketing activity. The mere fact that they can foresee that the article will be circulated and have an effect in California is not sufficient for an assertion of jurisdiction. Petitioners are not charged with mere untargeted negligence. Rather, their intentional and allegedly tortious actions are expressly aimed at California. Petitioner South wrote and Petitioner Calder edited an article that they knew would have potentially devastating impact on the respondent, and they knew that the brunt of the injury would be felt by respondent in the state in which she lives and works, and in which the National Enquirer has the largest circulation. Under the circumstances, petitioner must reasonably anticipate being held into court there. To answer for the truth of the statements made in the article, an individual injured in California need not go to Florida to seek redress from a person, though remaining in Florida knowingly caused the injury in California. Petitioners are correct that their contacts with California are not to be judged according to their employer's activities there. On the other hand, their status as employees does not somehow insulate them from jurisdiction. Each defendant's contacts with the forum state must be addressed individually. In this case, petitioners are primary participants in an alleged wrongdoing intentionally directed at a California resident, and jurisdiction over them is proper on that basis. 45 U.S. 788 9 to 90. Know how the court distinguishes worldwide Volkswagen. In this case, the dealership and the regional distributor did not engage in any conduct that was specifically directed to Oklahoma. In contrast, the National Enquirer's writer or editor intended to direct the conduct, the article, and the article's comments to a California market. Even though the author and editor of the article did not personally send the article to California, they intended for it to be sent there and purchased there. Accordingly, they purposefully availed themselves to the privilege of conducting activities in California. The unlucky tourist. Here's a multiple choice question closely modeled on the recent United States Supreme Court case Wadden v. Fury. Dudley, a Georgia citizen, works in security at an airport in Atlanta, Georgia. While at work, Dudley stops Lucky, a Nevada citizen who was at the airport for a brief layover during his trip home to Nevada from vacationing in Puerto Rico. During the layover, Dudley confiscated a significant amount of cash from Lucky, who claimed to have won it while gambling at a Puerto Rico casino. Lucky returned home to Nevada without his money, while Dudley filed an affidavit in Georgia as part of his effort to have the money forfeited to the government. Assume that Dudley knew that Lucky was on his way home to Nevada at the time Dudley confiscated the money, and also assume that Dudley knew Lucky was in Nevada at the time Dudley filed the affidavit. Assume that Dudley knew that Lucky was on his way home to Nevada at the time Dudley confiscated the money, and also assume that Dudley knew Lucky was in Nevada at the time Dudley filed the lawsuit. Lucky sues Dudley in Nevada court alleging that Dudley's affidavit was knowingly false. Assuming Dudley moves to dismiss the Nevada case on personal jurisdiction grounds, the motion would be denied because Dudley knew that Lucky lived at the time of the alleged intentional misconduct and was thus purposely directing conduct to Nevada. Deny, even if Dudley did not know where Lucky lived at the time of the alleged intentional misconduct, Dudley could have reasonably foreseen that his misconduct at a major national airport could result in harm to travelers to their home states. Both A and B are accurate, granted because Dudley did not purposely direct any conduct to Nevada. The case is this case is a useful companion to Calder because each case raises similar issues. In both cases, the defendant knew where the plaintiffs lived at the time of the intention allegedly wrongful conduct, and thus were expressly aiming their conduct at the plaintiffs in their home state. So, at first blush, one might conclude that both cases should come out the same way. That personal jurisdiction should be permissible in the case, just as in Calder. The Supreme Court, however, disagreed and distinguished these two cases in a unanimous opinion. In Calder, we examined the various contexts the defendant had created with California and not just with the plaintiff. By writing the allegedly libelous story, we found from forum context to be ample. The defendant relied on phone calls to California sources for information for the article. They wrote the story about the plaintiff's activity in California. They caused reputational injury in California by writing an allegedly libelous article that was widely circulated in the state, and the brunt of the injury was suffered by the plaintiff in the state. In sum, California was the focal point both of the story and the harm suffered. Jurisdiction over the defendants was therefore proper in California based on the effects of their Florida conduct in California. The crux of Calder at the reputation-based effects of the alleged libel connected the defendant to California, not just to the plaintiff. The strength of the connection was largely a function of the nature of the libel tort. However scandalous a newspaper article might be, it can lead to the loss of reputation only if communicated to and read and understood by third persons. Accordingly, the reputational injury caused by the defendant's story would not have occurred but for the fact that the defendants wrote an article for publication in California that was read by a large number of California citizens. Indeed, because publication to third persons is a necessary element of libel, the defendant's intentional tort actually occurred in California. Key in 465 U.S. at 777. The tort libel is generally held to occur wherever the offending material is circulated. And this way, the effects caused by the defendant's article, the injury to the plaintiff's reputation, and the estimation of the California public connected the defendant's conduct to California, not just to the plaintiff who lived there. The connection combined with the various facts that gave the article a California focus suffice to authorize the California court's exercise of jurisdiction. Applying the foregoing principles, we conclude that petitioner lacks the minimum contacts with Nevada that are a prerequisite to exercise jurisdiction over him. It is undisputed that no part of the petitioner's course of conduct occurred in Nevada. Petitioner approached, questioned, and searched respondents and seized the cash that issued in the Atlanta airport. It is alleged that petitioner later helped draft a false probable cause affidavit in Georgia and forwarded that affidavit to the United States Attorney General office in Georgia to support a potential action of forfeiture of seized funds. Petitioner never traveled to conduct activities within, contacted anyone, or sent anything or anyone to Nevada. In short, when viewed through the proper lens, whether the defendant's actions connected with the foreign petitioner form no jurisdictionally relevant contacts with Nevada. The best answer here is D. All right, and that's all we have for today. We will pick up tomorrow with Burger King versus Rod Zewix. I don't know. I need to learn how to pronounce it before tomorrow. Thank you for tuning into this episode of Legally Not Right.